Okay, well, thank you, Scott, and good morning, everyone. It is a pleasure to be here. I'm Andrew McAleavey, and what we're going to do today is I'm going to start today by talking about the U.S. patent system and the implications that has for applicants, as well as some tips for making your patent applications more compatible with the US system. And then when I'm done with that, my colleague Ken is going to pick up and talk about some specific prosecution strategies and ways of getting your patent applications through the US Patent and Trademark Office. So with that said, let's get going. I'm glad so many of you are able to join us today. And as Scott said, if you have questions, please feel free to put them in the chat box as we go through this. So part one, the realities of the US patent system. Now, on paper, the US patent system is governed by laws that are passed by the US Congress and also by rules that are set forth by the US Patent and Trademark Office itself, pursuant to congressional authority. Those rules are usually set by public comment notice periods where the Patent Office will propose to do something and the public will get a chance to comment on it. And that's kind of the legal framework in which the Patent Office operates. And knowing those laws and rules is very important, but the patent system is administered by people. And the point of my portion of the talk today is to talk to you about the constraints that those people are under and how they do their jobs. Because fundamentally, understanding what patent examiners do and how they do it, building relationships with them, understanding how they interpret the laws and rules is critical to getting a patent efficiently. So the administrative reality of the US patent system is that about 85% of patent applications are rejected at least once by the USPTO. And the USPTO says that about 50% of patent applications ultimately become patents. That means that according to the USPTO statistics, about half of people who want a patent don't end up getting one. In my experience, that's often because the client runs out of money, but Ken can talk about that a little bit later. Now, I want to start the discussion of what you can do to make your patent application process more efficient by talking about the process of writing quality patent applications. Now, in the US, and I'm sure in many of your countries, a patent application is considered to be one of the most difficult legal documents to write. And that's because, as many of you are aware, you must balance deep technical disclosure of what the invention is, how to make it, how to use it, with the legal details, the legal portions of the patent application. And when you do that, it is very easy to get stuck in small legal or technical details. I've had many clients who don't understand the depth of technical disclosure, for example, that actually does need to be in a patent application. My advice to you today is that while the details are very important, at some point in your patent application, you want to explain the function and the advantages of your invention in plain language so that those who are interested can easily understand. This includes patent examiners, and this will also serve you well at points later in the process. So moving on. One of the things is if you have quantitative data or specific examples that demonstrate how your invention is better than what came before, that sort of thing should be included. So just to give you a couple of examples, if you have an invention that affects heat dissipation, you can say something like Part A may increase heat dissipation, potentially increasing the life of Part B. Or in another case, this is something I actually worked on relatively recently. The light guide aligns the light rays so they're generally parallel to one another, which makes it easier to focus an image. And then a final example. Example 1 demonstrates that a reaction according to the present invention yields 30% more product than a comparable prior art synthesis. These are all things that are pretty plain language. They're not that legalistic. They're things that most people can understand, and they will help people like Ken and me ultimately to get you US patents. So with that said, I wanted to move on to something else and talk about patent examiners and the US patent system. And I'll begin by saying that patent examiners in the United States are required to have an engineering or science background. And what that usually means is a 4-year undergraduate degree in engineering or science with either a certain major concentration or a certain number of credits in engineering or science. However, most patent examiners have been in the USPTO for their entire careers, and many of them have very little outside engineering or science work. So when you work before the US Patent and Trademark Office, you can expect that a patent examiner will understand engineering or science fundamentals, but you cannot expect that they are experts in your field. To give you an example, when I worked for the Patent Office briefly, as Scott said, my background is in biomedical engineering, but I was in the art unit that was dealing with cleaning. So I dealt with dishwashers and washing machines all day. Now, as most of you will understand, that's pretty different than biomedical engineering. And obviously I was able to understand it, but I was not an expert in dishwasher design. I did learn a few things while I was there though. So the other issue is that patent examiners are not required to have a legal background. It has always been the USPTO's position that if you are an engineer or a scientist, you can learn the law related to patents. So as an example, I did not go to law school myself. Ken did. Now, the difficulty with this is that if you're not very carefully trained, and if you don't have a mind that works well for legal things, the lack of legal training can limit a patent examiner's ability to understand an argument, and it can also limit their ability to respond effectively if you make a legal argument. So that requires some special advocacy. Now, as Ken and I were preparing for this talk recently, we had a discussion and we realized that when practitioners like us look at an application, we are often focused far more on the inventive concept. We look at a patent application and we say, what did this person really invent? It's been our experience that in some countries, in some systems, the emphasis is more on specific embodiments or specific versions of the invention. And that can affect the way we do things. However, and this may be paradoxical, in the US, as in many other countries, I'm sure, the exact words of the claims are very important. And Ken and I view writing claims, writing patent applications fundamentally as an act of craftsmanship. And that is something that Ken will be talking about a little bit later. But for our purposes right now, I will say that when you bring a patent application into the United States, you want to invest in a good translation of your patent application into English. Even if your patent application was already written in English, you would want a US patent attorney or agent to review for the connotation and nuance, idiom. Just the other day, we found language in an application that we were going to file in the US that is perfectly descriptive of the invention, but also had some very negative connotations. And we worked with the applicant to resolve that and propose alternative language. These things are very important. Now, for the final part of my portion today, I wanted to kind of take you inside the patent office for just a moment or two to talk about the system in which patent examiners work. And fundamentally, what they call the production system says that patent examiners are required to produce a certain amount of work per 2-week period, per quarter of the year, and over the year as a whole. Now, how much work depends primarily on 2 factors. Number one is how senior is the patent examiner. Senior patent examiners are required to produce more work than junior patent examiners. Also, it depends on the technology area in which the patent examiner is working. Some technologies, patent examiners are given more time than others. And on this slide, I've given you an example. In general, biotechnology patent examiners are allowed to spend more time per patent application than are mechanical patent examiners. Now, there's a way this works out numerically and technically, but essentially, what I want you to take away from this is that the way the USPTO system works, patent examiners are given more credit for the initial examination of a new patent application and the writing of what we call a first office action on the merits of that application than they are for any subsequent activities related to that patent application. So they get less credit for responding to your first office action and either issuing a final office action or allowing your case for issuance as a patent. And then there's this phrase, request for continued examination, that will come up later in the talk. So let me define it for you briefly. A request for continued examination is a way of saying, all right, I know you've considered my application and you've given me a final rejection. Here is some more money and here is another submission. Please reopen the prosecution and consider my new submission. Yeah, the problem with that is there is a heavy cost. I don't have the numbers in front of me right now. As a matter of fact, Congress just changed them recently, but you're looking at 12 to 1600 easily and more once the U.S. attorney's fees are considered with that as well. So moving right along here. What this means for you is, in practice, the second office action on the merits is required to be final. And there's another trick that patent examiners use that I wanted to talk about briefly. Patent examiners can decide that your patent application contains more than one invention. This is called a restriction requirement. And restriction requirements can be justified in situations where there really are different or unrelated inventions that are disclosed in a single patent application. But I will tell you from experience that patent examiners use restriction requirements as a tactic to delay a case, to get it off of their dockets. They don't have to work on it. And they also use it to break up a patent application so they can get more credit for examining a patent application that they already basically know. Now, what does all of this mean for you? Fundamentally, what it means is that you want to put as much effort as possible into your patent application and your patent claims before you file the patent application in the United States. That is my most fundamental piece of advice for you today. If you can't put the effort in before you file the patent application, then you do have considerable time before the patent application is examined, where you can do what we call a preliminary amendment and put your claims in good shape for examination. You want to ask yourself, if I got a patent on the claims that are in my patent application right now, would I be happy? And if the answer to that question is no, you should do something about it before the patent application is examined for two reasons. Again, because the patent examiners get the most credit for the first action on the merits, and also because the next action in your case is likely to be final and you could be required to pay more money. So do it right, do it quickly. All right. Now, the other tactic I have to suggest to you today is that you strongly consider what we call an examiner interview, talking to the patent examiner. And this is another situation where law, rules, and practical patent practice differ somewhat. The USPTO's rule is that all correspondence relating to patent applications, everything must be in writing. However, we are permitted to talk to patent examiners, and we strongly suggest that you do it. So because that allows you to test your ideas for patentability, to see what the patent examiner thinks. In many cases, I will not argue with the patent examiner initially. Oftentimes, I will talk to the patent examiner and say, all right, I've read your office action. What would you like to see in this applicant's patent claims? What do you think is necessary to get this case through and get this client a patent? And a good patent examiner will often have an answer to that question. All right, so to summarize, Put as much effort as possible into your patent claims before filing or by preliminary amendment. Put as much effort as possible into your claims in responding to the first office action. And you do want to strongly consider talking to the patent examiner after you get that first office action. And I'm looking at the screen now, and I'm really not seeing many questions pop up. Please do, again, feel free to pose questions in the chat box, and Ken and I will be happy to answer those questions when we're done with the primary portion of our presentations. With that said, I'm going to turn it over to my colleague, Ken. Before I do, I just want to make a quick comment that something Scott said earlier. Yes, Ken was one of my early mentors. He really focused a lot on legal skills and making an argument in writing, and I'm forever grateful for that. Our careers have diverged a little bit since we first met. It's interesting that Ken and I can debate points of law all day because we enjoy it. But fundamentally, our approaches may differ a little bit from case to case, but our values are very similar. And I think both of us came to United IP Counselors because we wanted to work together again. So with that said, I am very happy to turn the case over to Ken. And I'm also going to point the camera at him to make it a little easier for him to talk. So Ken, all yours.
Good morning, everybody, or good evening, as the case may be. Thank you, Andrew. Thank you, Scott. Yeah, I'm Ken Fagin, and I have been a patent attorney for 30 years. For the first few years of my career, I focused mainly on litigation, but I've done prosecution for the entirety of my career. There are some people in the United States, certainly in the US legal or the US patent community, who think that litigation is the glamorous side of the practice. And they think that that's where the hardcore legal work is done. I would actually beg to differ with that. I think it takes as much advocacy skills to do prosecution effectively as it does to litigate a case. There are a few things that we tend to emphasize here. Or principles, guiding principles. Scott just brought me the information on the RCEs, by the way. I'll get back to this in a moment. Some guiding principles that are philosophies that sort of motivate the way we practice here. We like to tell clients, it's your IP, protect it as broadly as possible. It's your money, keep it. In other words, we try to minimize the expense that it costs to prosecute a case before the patent office. Going back to what Andrew was talking about on the cost of RCEs, requests for continued examination, the first request for continued examination for a large entity is $1,360, which is about the cost of an application filing itself. Second or subsequent RCEs are about $2,000. So it becomes very, very prohibitive as cases drag on at the patent office, which is why we do whatever we can to get a case allowed and out the door. At UIPC, we do a substantial amount of work for foreign clients. Years ago, people would refer to this sort of practice as fax practice. And what that meant was a US law firm would receive instructions from an overseas client, often by facsimile, saying, this is what we want you to say to the patent office. And the US firm would simply take those instructions, copy them over, and submit them to the US Patent and Trademark Office without any additional thinking or guidance or input. Here at UIPC, we try to do more. When I first started doing foreign originating prosecution about 22 years ago, I was working for a couple partners at a law firm who had a sizable practice representing Japanese clients. And one of those partners gave me their docket to manage. And I was reviewing incoming instructions. And I had the audacity to ask one of the partners, hey, I have an alternative suggestion for how we might be able to get this case allowed a little bit more quickly, a little bit more easily. May I write back to the client and suggest this or make this alternative suggestion? And the partner actually allowed me to do that. There are some practitioners that would say, oh, no, you can't do that. You have to do exactly what the client tells you to do. But I always viewed this as a partnership with our overseas clients. And so I wrote back to the client and said, hey, thank you for your instructions. We understand it, but here's an alternative suggestion you might wish to consider. And the client actually allowed us to take this approach, and we were able to bring the application to allowance much more quickly. One of the difficulties that we face here in the US is what we refer to as compact prosecution. Basically, this is a policy at the patent office of trying to get all the issues resolved as fast as possible and with a single office action. The practical effect of this is you get one chance to amend your claims in response to a non-final office action. And after that, if you have not gotten your case allowed or in condition for allowance, prosecution is closed, and your ability to amend the claims afterward is significantly limited. This is in contrast to many other countries where you have 2 or 3 opportunities to amend the claims before the prosecution is closed. So the practical effect of this is we try to get the application in the claims in the best condition possible right from the very beginning. As I mentioned, after a final office action, the ability to amend the claims is very limited. And so what we do here is we make sure that finality is proper. And what this means is we check to make sure there are no new grounds of rejection that have not been necessitated by something we have done. If there is a new ground of rejection, we'll go back to the patent examiner and say, hey, this finality is not proper. You need to reissue the office action as a non-final, which gives us another opportunity to amend the case a little bit further as necessary. Did you want to touch on this? Okay. To emphasize what Andrew was talking about previously, examiners are working under tight constraints. They don't have a lot of time for every application. And as a result, very frequently an examiner will do what we refer to as examining the claims. In other words, they look at the claims out of context without reading the entire application. As a result, it's up to us as the practitioners to explain to the examiner what the application is really all about. Can you jump ahead? Yeah.
Oh, jump ahead.
Jump ahead, yes, please.
All right.
This is where advocacy comes in. It's up to us to explain to the examiner what the application is about, how the inventive concept is reflected by the claims, and why the claims define the invention in a way that is different than the prior art. There are some examiners or some practitioners who view patent prosecution as a negotiation, trading with the examiner to get something allowed. We don't take that approach. In our view, if an examiner is going to deny an application, the examiner has to support their position and prove that you are not entitled to the patent application or to the patent. This is what we mean by advocacy-based prosecution. If you're going to deny the application, prove it. Otherwise, we are entitled to the application and you have to give it to us. In other words, do not let the examiner force an applicant into accepting claims that are narrower than what the applicant is truly entitled to. In order to do this effectively, it is incumbent on your representative that they take the time to read the application, understand it. Not only does this allow your representative to be able to find or figure out the most effective amendments if necessary, or to explain what the application is all about, to distinguish over it. It allows the representative to argue what the inventive concept is and to explain how it is different than the applied prior art, or if necessary, to go in and make the suitable amendments to define over the prior art. When an examiner issues an office action that says, I reject your claims because such and such reference shows your claims, the examiner has already made a determination in their mind that the claimed invention is shown in the prior art. A response that simply says, no, it's not, does not advance the applicant's case. In order to get the examiner to change their position, it's important to get them to understand why they are wrong. It takes explanation. You need to point it out. You need to explain where you are coming from in order to get the examiner to say to themselves, you know what, you're right. I was wrong. I'm going to withdraw the rejection. There are some practitioners who refuse to take a position on the record. They will respond with very vague or general assertions. In our view, you have to take a position on the record in order to advance your cause. As long as what you are saying on the record is in keeping with the inventive concept, it's okay. We need to be mindful of making statements on the record that might limit the scope of coverage, but it is okay to tell the examiner what the inventive concept is so that the examiner understands your position and is more willing to allow the application.